Welcome to On the Chain.
Now, obviously, positive news because the SEC had some missteps. Now, it's not over, right? So the case isn't over, but positive news. There's information coming out that is basically saying that, hey, you know what? There's some things that weren't told to us that are 100% accurate. And now there's documentation to actually show that it wasn't 100% accurate. So, Jeremy Hogan, I'm reading it. Can't believe it. Now, the speech wasn't Hinman's personal opinion at all, but intended to convey the Department of Corp Finance's position on digital assets. What? Like, what? Um, uh, no, because all these years you've been telling us that's personal opinion. Oh, he was invited to speak on behalf because of his position with the SEC. Oh, but it's personal opinion. And he was standing with the SEC logo. Oh, but it was personal opinion. Oh, okay. I get it. Right. So, Jeremy Hogan, in the legal world, this is as crazy as it gets. The Ripple lawyers must be chomping at the bit. Now, rank amateurs, right? So, we've heard the commentary from the SEC against retail investors, against those that are buying into XRP. There were statements that they put in front of the court that said that holders of XRP were not technologically savvy enough to understand. The SEC treats people in the retail space if you're not an accredited investor, that you don't have the same rights to better yourself through investment, regardless if it's a risky investment or not. All right, this one is from James Filan or Filan, sorry, butcher your last name. So 5 tweets, right? Overall, favorable to Ripple and the individual defendants. Both memos are from Perkins Coil. The first memo was prepared in February 2012 and sent to Jeb McCaleb and Jesse Powell. It says that if new coin, this is what XRP became, if new coin is sold in what would now look like an ICO, 2.5, I didn't see the term ICO used. It would be likely that it would be considered a security. But Ripple then revised its business plan and went back to Perkins Coil, which issued a second memo in October 2012. The second memo was sent to Chris Larson and Jed McCaleb. The October memo was more positive, and while it said that there was a small risk that the SEC would disagree or could disagree, Perkins Coil concluded that Ripple credits should not be considered securities. The memo also suggested steps Ripple could take to minimize the risk that the SEC would disagree with Perkins Coil. The memos cover the full landscape of legal issues, not just the issue of securities, and I think show how careful Ripple was trying to be. Now, it is 2012. They sought out legal analysis to dissect before they made any moves forward. So think about that. Also, this was 5 years before the SEC really even started talking about digital tokens. It seems to me that Ripple was being very proactive, which is very important. There certainly is nothing in these memos that suggests that Ripple was being reckless or ignored any substantial risk. In fact, the memos suggest the opposite, that Ripple was being careful. So think about that. Think about how important that is, how careful, and that they didn't want to have any missteps. They wanted to be very, very clear on what they did. In fact, Stuart Alderoty comes and says the conclusion of these now 2012 memos is clear. XRP do not constitute securities. The fact that Ripple had the foresight to seek legal advice from a prominent firm in 2012 in the absence of clear case law and 5 years before the SEC even started talking about digital assets should be applauded. That's exactly right. That should be applauded because that's what they did. Again, these weren't a bunch of lackeys. They didn't just step up and do, and do nothing. They stepped forward and tried to really investigate and make sure that everything that they did was spot on, and going through with full transparency. So, so it's just phenomenal. It's really phenomenal to see this coming out. And we got some bright minds that have been providing commentary on all of this, right? Keeping us informed, making sure that we understand the specifics of what's happening. So, I mean, God, it's unreal. So John Dean says, I've said for a year, the SEC lawyers are 100% transactional. They will say whatever it takes to win a particular argument, no matter how inconsistent that argument is with other statements or arguments they have previously made. That's a massive statement. Why? Because that means if they're inconsistent and if they made previous arguments and now they're making a new argument, then one of them isn't true. The inconsistencies shouldn't hold up in court. They shouldn't be able to say and do whatever they want to say or do. And it's being pointed out. And John Deaton has filed suit on behalf of the XRP community against the SEC. So all of this information, all of these misdeeds and missteps and misstatements, or however you want to phrase them, are piling up in the case against the SEC. So Bill, he had said here, so now the SEC says that not only was Hinman's speech used by SEC staff to provide market guidance, but that by SEC regulations could be relied on as representing the views of the SEC's Corporation Finance Division. What? I mean, right? That's exactly what we read earlier. Just going back and rehashing. So here you say, I truly don't understand. Isn't all this flip-flopping constitute a straight up lying? How can any of this slide in court? Is the justice system truly this horrendously flawed? My brain cannot comprehend the mental gymnastics at play here. Bill's response back, it's a bullshit show, everyone, all theater, and it isn't over yet. This case will not decide anything, and no one will get fined or go to jail. It will get thrown out. And now the big save will happen next week because of national security. So we'll see how that unfolds. A system over immediately to compete with the rest of the world and stay on top of the financial world. This is the so-called black swan event for the new digital currency system to be put in place to pull us out of a financial attack of worldwide proportions. What is going on, right? So there's a lot of commentary, a lot of opinion on what's happening. I do believe that something of this proportion doesn't go to settlement. The court, in my opinion, not an attorney, is going to have to find and issue a final judgment. That's it. There has to be a judgment on this. This cannot go to settlement at this point. It has to go to judgment. There's too much now at stake because there has to be a final conclusive outcome. After all this time, I do not believe that Ripple is going to sit back and say, hey, yeah, let's we're good. Let's settle. We'll let you off the hook. The SEC does lose. You just never see the cases they lose because they end up on the back page somewhere buried. You know about the ones they win because they pat themselves on the back. It's so crazy. So crazy.
Are you down with OTC? Please like, subscribe, and click the bell to be notified when the next video drops.